if you're talking about implementation of court orders, I don't think there's a difficulty. Anybody brings it to the notice of the court, we threaten them with contempt of court proceedings and we can implement it. That's not an issue at all. I think the matter of concern is more with regard to the willingness to act, because you find the executive invariably taking in matters that they don't want to implement, they can take a soft pedal approach. So there it becomes a little trickier, because we have over the years developed a concept of continuing mandamus, which is basically, telling them to do something and then following it up periodically to see whether they have actually done it. And we keep the case pending and we keep monitoring that. So that has helped to a considerable extent in getting our orders implemented. But the grassroots level, the people, the task forces, as I mentioned, they're instrumental in bringing it to our notice, because sometimes with the kind of caseload that we have, we seldom get the luxury of having to monitor each case and each order that we've passed.
As far as the zoning is concerned, Gopi, it's not cast on stone. It's quite flexible. All that the original document said was core, buffer, and transition. But different biosphere reserves across the world have interpreted it in a different and very imaginative manner. Some call it the manipulative. Some call it the cultural zone. Kasturi Rangan called it the cultural zone. The manipulation zone, the cultural zone. Now it can be developed as we go along. The broad guidelines are there in the original document, but we can develop it keeping the local reserve centric. So there is also the restoration zone. The restoration zone is not there. If it had been there, we can bring certain kind of restoring activities to the degraded forests. Now, quickly, while on the restoration zone, which some countries use it. Last year, the European Union has passed a law called Nature Restoration Law. It has been adopted by the Environmental Council of European Union. So I would recommend this seminar to take that as a concept, and people like Suma can advise the collector to write to the government. When we say core, we do not know the quality of the core. When we say the buffer, we know how it has been damaged. The transition, in the Nilgiri context, the urban spaces have been left out. So it's been left out because it has been degraded. How to restore it? Instead of calling them as transition zone, we can call them as restoration zone. Once we call it a restoration zone, it's implied it's degraded. So it's quite flexible.
Judicial overreach, trust me when I say that, when a judge actually decides matters in a constitutional court, we are walking the razor's edge. We don't want to actually, overstep. We're trying to, do something in accordance with the Constitution and the laws. But then you have people like our lawyer friend Sanjay here, who come and tell us that, the heavens are going to fall down and you need to do something now. And that's when all hell breaks loose. And we start issuing directions based on, nothing more than what the lawyer tells us. And he tells us about a situation on the ground which needs urgent action. And we do it in the best way we can. And that's only to see that there's something happening. Normally, we don't legislate. As an institution, the judiciary is not supposed to legislate. We do sometimes issue directions which are in the nature of legislation, which are in the nature of guidelines, and that is only to as a pro tem measure. You issue those directions and you wait for the legislature to step in and make a law. Except that's not been happening quite effectively in our country. For example, we had the Vishaka guidelines to deal with a particular social evil, which was sexual harassment of women in the workplace. We issued those guidelines in 1986. The law came 17 years later. So if that's going to be the time taken for implementing a law after we've actually flagged the existence of a social issue, then you can understand why the guidelines which remained in force for about 17 years were seen as overreach. Of course, it was overreach if you go by the strict separation of powers doctrine. A word about the legislations and the mosaic of legislations we saw. I was just thinking about it as we sat here listening to Sanjay. One of the aspects that could be a reason for the mosaic structure that we have now is because our environmental legislations have always not been in the conventional or traditional manner in which laws are made in this country. How a law is made, you would look for a competence or a subject on which you want to make a law. You'd go to the Constitution, go into the 7th schedule of the Constitution, look at the legislature which has the competence to legislate on that subject. Now you have 3 lists in the 7th schedule. You have the union list, the state list, and the concurrent list. The union list is where only the parliament can make laws. State list is where the state legislatures, and the concurrent is where both can. Now, if you search for the word environment, you won't find it in any of these entries. You won't find it in any of these lists. You have individual entries like rivers, forests, prevention of cruelty to animals is there. It was inserted subsequently. It was not there originally in the Constitution. So over the years, we've been trying to introduce these things, but yet we don't have something, an entry which deals with environment per se. Now, you could possibly read it as a residual entry in the union list, entry 97, which basically means that if there is nothing mentioned elsewhere in the Constitution, the residual power is with the union. Now, this militates against the concept of federation that we traditionally know, where the residual power is always with the states. But India is a quasi-federation. So we don't have the federal concept. If you read the first article of the Constitution, it says India that is Bharat, is a union of states. So our concept of federation is more of keeping states united in India. It was not the American concept of states conceding some of their powers into the federation and retaining the residual power. So you have a residual entry for legislation, but that has not been used, more so in environmental matters. So we resort to Article 246, which says that the union can give effect to international conventions and agreements through local legislation, and we legislate directly through that provision. So that's why we have the mosaic of legislations and regulations and not one single legislation. So when you have a mosaic, I think we need to take cue from the cockroach in the animal kingdom, which is also credited with mosaic vision. The cockroach is a compound eye, and the compound eye picks up, separate units of that eye pick up different parts of an image, and they all converge to form the whole image. So that's, I think, what we need to look to. Although I heard Siddharth mention that he was scared of one legislation, but I think in terms of a convergence of the philosophy behind individual legislations, we need to have now an ecocentric philosophy informing all the legislation, and not diverse philosophies coexisting at the same time, because that's simply impossible.
Said one thought on the judicial overreach. In fact, we are struggling to say that judiciary is not really aggressive on many aspects. If you see and if you do some trend analysis, you'll find there's judicial aggression on very small things. Like in Delhi, you also have how many sweepers should sweep Delhi, compared with huge dams in the northeast, the Dibang and the lower Subansiri just getting passed by one word, dismissed. So I think we need a lot of judicial aggression on the larger issue, and it's not enough. And that's with a lot of experience in this, on a daily basis that I find. Yes, there are sometimes judicial overreach, which, I mean, the stray dog is a great example, which is doing the headlines. But we are not discussing it here, I'm sure. But I think we need a lot of judicial aggression. And of course, not crossing that line with the razor edge that Honorable Judge just spoke about. But I think we still need a lot of judicial aggression, and thank God for that we've done. And I think continuous mandamus, for whatever people say, still has a lot of effect. I mean, we know the Godavarman case that started from Gudalur here, and the Environment Awareness Forum from Kashmir. But it is still, I have a 3,000-page book on it, anybody's interested. But I think it's still important for forest conservation in this country. The MC Mehta since 1984, the CLWWF India case, where Vijay, you know it more than me, from 1995. I think continuous mandamus is still a great idea. Thank you. So, wildlife is government property. That's the word used in Section 39 of the Wildlife Protection Act. It needs to change, certainly, because at the end of the day, I think habitats for wildlife and the government has to be only a custodian, not an owner. And in the larger scheme of things, they are custodian. It may be not very happily worded in 1972, because that's what we followed from Stockholm. But I think it's only a play of words. The state is still just a custodian. So I don't think there's enough, there's no point in having a huge discourse of it's a government property and therefore there is some bias towards that. They are still a custodian and that's how it will be. So that's the jurisprudence that we've seen. When conversions are happening, and now with this whole concept of deemed forest and the environmental compensation regime that has come for transferring those tea estates to other kind of real estate, I think there are some checks and balances which needs to be understood a little more, so that those compensation mechanisms which are now in place is used better for having that corpus of money for conservation work. So that's my quick response.
The straight answer to your question is environmental litigation in our country did not have to go through the PIL route at all. Any other case that comes into courts will come through a civil court, right? So you have a facility of complaining against a particular problem. You can approach the civil court. There you would go through the procedures for adducing evidence, scientific evidence, expert evidence would come in, and the judge would decide the matter at the grassroots level with the available evidence, with access to the neighborhood where this thing is happening. Why? What is the appeal in PIL? Fast tracking of procedure. And what is the flip side? You lose out on evidence, because you must understand how writ courts work. They work, there is no formal system of evidence taking. You rely on affidavits and counter affidavits. Now, can you imagine a situation where, and it leads to all sorts of incongruous situations. I mean, we're giving directions as to when rhinoceros in Kaziranga should mate. I mean, these are not the preserve of judges, and this is certainly not anything that I have knowledge about. And this is happening because you're not going to the forum which is competent to decide. So when matters of evidence are required, if you want to understand what exactly is a Shola forest, what is the nature of a Shola forest, adduce evidence before the first court where they can actually look into it, and then have a solution. Of course, it's time consuming, but isn't it better to have a time-consuming but a certainty? Because otherwise, we're just doing something arbitrarily, and we are doing it without knowledge, and then trying to correct the mistakes later on. I think that's a better approach. Understand what you're trying to do. You're trying to protest. You have the ability to approach it, have legal access to prevent it. You can go to court. Any citizen can go to court. You can take anybody to court.